She had not spoken once in 14 weeks. Not a single word. Not a question, not a comment, not a correction. She sat in the same chair every Tuesday and Thursday, third seat from the right, back row. The chair closest to the window that overlooked the quad, and she listened with a particular quality of attention that most people in that classroom had never bothered to distinguish from absence. Professor Leonard Ashby had certainly not distinguished it. He had taught constitutional law at Alderton University School of Law for 19 years, and in 19 years he had developed a refined taxonomy of law students: the eager front-row performers, the competent midfielders, the passive back-row occupants who showed up and said nothing and would, in his estimation, struggle in practice because the law rewarded the people who spoke. He had placed the quiet woman in the back in the third category on day one and had not reconsidered since. Her name was on his roster, Simone Okafor. He was not certain he had ever said it aloud. Today was different. Today was the day the third-year class conducted their annual moot court simulation, the capstone exercise, the one that counted, the one that replicated a live appellate argument in front of a 3-judge panel drawn from the law school's faculty. 92 students. Every student had been assigned a side, a case, an argument. Every student would speak. Simone Okafor had drawn the appellant's position in a First Amendment case that Ashby had designed specifically to be complex enough that even his strongest students would struggle. He had no idea what was about to happen. Neither did the rest of the classroom. But the woman in the back row did. 7 years earlier. This is where it really starts. Simone Okafor arrived at Alderton Law at 44 years old, which was, in a class whose median age was 26, an anomaly that certain professors noted with the particular interest of people who respect late vocational changes, and that others noted with the specific, unexamined skepticism of people who believe that the law belongs to the young. She had not come to law late because she hadn't known what she wanted. She had come late because the life that preceded it had required her full attention, and she had given her full attention to the things that required it without flinching or postponing or doing them halfway. This was simply who she was, a woman who finished things, who stayed until the things she had started was completed correctly, who did not leave rooms before the work in them was done. She had grown up in Detroit, in a household where her father had worked 31 years in the auto industry and her mother had taught elementary school, and both of them had understood, had transmitted, through the daily example of their lives, without ever making a speech about it, that competence was not optional, and that the people who forgot this eventually paid for the forgetting. She had married at 27. She had 3 children. A son named David, who was now 22, a daughter named Kezia, who was 19, and a second daughter named Ruth, who was 16 and still at home in the Philadelphia suburb, where Simone and her husband James had built a life over 17 years. James was a structural engineer. He was the kind of man who built things to last, which was one of the things Simone had recognized about him in the first year they knew each other, and had never stopped being right about. She had spent the years between her own education and law school doing several things, none of which appeared on the standard law school applicant profile. She had been a paralegal at a civil rights law firm in Philadelphia for 11 years. The kind of firm that did Title VII employment discrimination cases and housing discrimination claims and the unglamorous, load-bearing work of law that doesn't get profiles in legal magazines. She had managed the research function for a team of 6 attorneys, which meant she had done the work that the law runs on, the case analysis, the statutory interpretation, the pattern recognition across fact sets and precedents that determines whether a claim lives or dies. She had also, in year 8 at the firm, been the person who had identified the argument that won Garrison v. Caldwell County, a housing discrimination case that the firm had been working for 3, years and that had been stuck at the circuit level on a standing issue that Simone had resolved by finding a precedent in a 1974 administrative law case that nobody on the attorney team had thought to look for, because it was not in the case law database they had been using and required the kind of lateral, cross-disciplinary search methodology that Simone had developed across 11 years of research in a firm that required the impossible on every case. The lead attorney, a woman named Patricia Haynes, had put Simone's name in the brief's acknowledgments. Simone had found this insufficient. Not for her ego, she was not a person with an outsized ego. For the next client, for the next case, for the gap between what a paralegal could do and what an attorney could do, which was not a gap in knowledge, but a gap in standing, in whose voice the court would hear and whose it would not. She had applied to law school at 43. She had been admitted to Alderton with a scholarship. She had been the oldest student in her class by 9 years and the quietest student in every class she took, which was not because she had nothing to say, but because she had learned, across 11 years in a firm where the attorneys spoke and she researched, and the difference was credentialed rather than intellectual, to be certain before she was audible. She was almost always certain. She was almost never audible. This was about to change. Leonard Ashby ran his classroom the way he ran everything, with the brisk, confident authority of a man who has been the smartest person in most rooms for a long time and has stopped checking whether this remains true. He called on students in a pattern that was not random, though he believed it was. The front row was called on frequently. The middle rows, when they raised their hands. The back row was called on occasionally, and with a tone that suggested the question was a formality rather than a genuine inquiry. He had a particular way of tilting his head slightly when a student gave an incorrect answer. Not an unkind gesture, just an involuntary one. The physical expression of a man recalibrating downward. He had tilted his head at Simone Okafor twice in the first week. The first time when he'd asked the class to define the Establishment Clause and she hadn't raised her hand, and the second time when she'd arrived 3 minutes late to the Thursday session in week 2, and he'd marked it in his attendance record with the specific emphasis of a man storing evidence. He had not called on her since. She was, in his informal taxonomy, one of the students who was getting through on borrowed time, showing up, staying quiet, absorbing enough to pass, but not enough to practice. He was spectacularly wrong. But here's how wrong he was, not just about her preparation, but about the whole apparatus of his certainty. Simone Okafor had read every assigned case for constitutional law before the first class session. Not summaries, the full opinions, including the dissents, which most students skipped because the dissents weren't on the exam. She had read them because she had been trained, across 11 years of appellate research, to read dissents the way other people read weather forecasts, as the most accurate available description of where the law might go next. She had written, in the margins of her casebook, annotations that connected each case to its regulatory and legislative context. Because context was where the argument lived, and context was almost never in the casebook. She had found, in week 4, a flaw in the way Ashby was presenting the line of cases around compelled speech doctrine. Not a small flaw, a structural one, a lineage error that conflated the rationale in 2 cases from different doctrinal branches in a way that would produce an incorrect outcome if a student applied the framework to a real fact pattern. She had checked it 3 times, because she did not make accusations without checking. She had confirmed it on the 4th check using a law review article from 2018 that Ashby had not cited and may not have read. She had not said anything. She had written it in her notebook and put a star next to it and continued listening. She had also been tracking the case he had assigned for the moot court simulation. a First Amendment challenge to a state university's content-neutral social media policy, whether the university's restriction on student speech on university-affiliated platforms constituted a prior restraint under the First Amendment or was a permissible time, place, and manner restriction. The case was designed to be hard because the answer genuinely was hard. There were 3 possible frameworks, each with legitimate precedential support, and the typical law student would reach for the most obvious one and build an argument that was technically sound but strategically incomplete. Simone had not reached for the obvious framework. She had spent 6 weeks building an argument on the least obvious one, a line of compelled speech cases that had not been briefed in the semester's curriculum, and that, applied correctly to the social media policy's specific language, produced an outcome that made the restriction not merely unconstitutional under the prior restraint doctrine, but unconstitutional under a different and more durable rationale that would withstand the 3 standard counterarguments that Ashby had built into the case for exactly the purpose of defeating the obvious approach. She had found it in a footnote in a 1995 Seventh Circuit opinion. That was the kind of researcher she was. She had not told anyone. She had sat in the back row, 3rd seat from the right, and waited for Tuesday. Tuesday arrived at 9 o'clock. The moot court simulation was organized as a full appellate argument. 2 students on each side, 20 minutes per side, a 3-judge panel of faculty. The panel included Ashby, a property law professor named Dr. Chenwei, and a visiting adjunct named Judge Margaret O'Shea Bokier, a retired state court judge who taught evidence seminars twice a year and whom Ashby had invited because she was, as he told the evidence department, the kind of judge who asks the hard questions. He had no idea how relevant that would be. The first pair, 2 students arguing the respondent's position, defending the university's social media policy, presented a competent, unremarkable defense, content-neutral, viewpoint-neutral, survives intermediate scrutiny. Standard correct as far as it went. Ashby made 2 notes. Judge O'Shea Bokia asked 4 questions. Dr. Chenwei asked 1. Then the appellant's side stood. The first student, a young man named Tyler Benson, front row regular, class participation percentage of 982, presented the prior restraint argument. It was the obvious approach, well executed, the argument Ashby had anticipated from the moment he designed the case. He had built the counter-arguments to defeat it, and they did. He asked 3 questions from the bench, and Tyler handled the first 2 cleanly and the third with visible strain. Then it was Simone's turn. She stood from the back row. The walk to the front of the room was 23 steps, which she crossed at the unhurried pace that was simply her pace. The pace of a woman who had learned that arriving at things at the speed they required, rather than the speed of performance, was its own kind of authority. She set her notes on the podium. She looked at the panel. "May it please the court," she said. It was the first time Leonard Ashby had heard her voice all semester. It was not the voice he had been expecting. Not tentative. Not apologetic. Not the voice of someone who had been sitting in the back row absorbing without contributing. It was the voice of a woman who had been doing this work, not the performance of this work, but the actual weight-bearing work of it, for 11 years before she set foot in this classroom. "I want to respectfully set aside the prior restraint framework," she said, "and argue instead under the compelled speech doctrine, as articulated in the line of cases running from Barnett through Woolley and forward. I'll explain why that framework is both more durable and more precisely applicable to the specific language of this policy." Ashby's pen stopped moving. At the back of his mind, something stirred. The flaw he hadn't noticed in his own doctrinal lineage. The place where the compelled speech cases and the prior restraint cases diverged in a way that he had, in semester after semester of teaching this material, never cleanly distinguished in his classroom presentation. She was about to distinguish it. In public, in front of 2 colleagues and 91 other students. She began. She spoke for 11 minutes before the first question from the bench. The question came from Judge Osei Bokia, who had been leaning forward since approximately the 3rd minute with the expression of someone hearing something being done correctly and wanting to confirm that it was as correct as it sounded. Her question was precise. Counsel, how do you address the respondent's argument that the policy is viewpoint neutral, which has historically taken compelled speech claims outside the Woolley framework? Simone had anticipated it. She had prepared for it specifically, because it was the best counter-argument to her approach, and she had spent 3 evenings stress testing her response against it. Your Honor, viewpoint neutrality is a necessary but not sufficient condition to remove a regulation from Woolley's reach. The question is not whether the university is restricting a particular viewpoint, it's whether the policy, by requiring affiliation with the university platform as a condition of certain forms of academic participation, compels students to associate their speech with an institutional voice they may not endorse. She paused. The policy's language specifically requires that students posting on affiliated platforms include a university attribution tag. That attribution tag is the compelled speech. The university isn't silencing the student. It's making the student speak in the university's name. The room went quiet in the specific way of 91 people understanding something simultaneously. Judge Osei Bokia sat back. Her expression had shifted into something that was not quite a smile, but occupied the same emotional territory, the expression of a jurist who has just heard an argument that is going to require a real answer. Dr. Chen Wei asked 2 follow-up questions. Both were excellent. Simone answered both with the focused precision of someone who has lived inside this analysis for 6 weeks and has found all the edges. Leonard Ashby had not asked a question yet. He was still. Not theatrically. Not the stillness of a man performing astonishment. The genuine stillness of a man whose internal recalibration was running faster than his external expression could keep up with. He was thinking about his lineage presentation. About the specific semester he had first taught the case. About the 14 weeks of this semester and the quiet woman in the back row whom he had categorized on day 1 and had not reconsidered since. He asked his question at the 13-minute mark. It was not a hostile question. It was, and this was something that Dr. Chen Wei would mention to a colleague later and that Judge Osei Bokia would think about on the drive home. It was a genuine question. The question of a man who is, at this specific moment, actually trying to understand. Miss Okafor, he said, your framework resolves the constitutional question cleanly, but it requires the court to accept that the attribution tag constitutes speech by the student rather than regulatory labeling by the university. How do you establish that distinction without the court finding it too attenuated to trigger First Amendment scrutiny? Simone looked at him. In the back of her mind, the part that had been sitting in this classroom for 14 weeks, the part that had found the doctrinal flaw in week 4 and written a star next to it and said nothing. Something settled. Not triumph. Something quieter. The recognition of a question that deserved to be answered well, coming from a man who was, for the first time, all semester, asking her something he actually wanted to know. She answered it. Precisely, with a 2019 Ninth Circuit case that had resolved an analogous question about student media affiliation policies. The case was not in the syllabus. She had found it in October and had spent 2 weeks mapping it onto the moot court fact pattern. She cited the case. She cited the page number of the relevant holding. She explained the application in 4 sentences. The room was absolutely still. Then Judge Osei Bokie said, "Counsel, that's the most thorough appellate argument I've heard in this classroom in 7 years of teaching here." She said it simply, as information. The way judges communicate, without decoration. 91 students turned, almost involuntarily, toward the back row. The back row was empty. Simone was at the podium. The debrief lasted 30 minutes. Judge Osei Bokie led it. She had the specific authority of someone who has spent decades in actual courtrooms and is not interested in the management of feelings over the communication of substance. She walked through the simulation with the directness of a former judge who knows that clarity is kindness in a professional context. She told Tyler Benson his prior restraint argument was technically sound and strategically predictable, and that real appellate courts expected the obvious approach and had the counter-arguments ready. She told the respondents' team they had defended the obvious framework well and been exposed by an approach they hadn't prepared for, which was itself a lesson. Then, she said, Miss Okafor found a framework that this simulation's design did not anticipate. She looked at Ashby with the measured expression of a colleague saying something that a colleague needed to hear. The compelled speech argument is not only more creative, it's more durable. The prior restraint approach has 3 structural vulnerabilities that the respondent would exploit on the second round. The compelled speech approach has one, and Miss Okafor addressed it with a case none of us brought into this room. She paused. That's not luck. That's the kind of research that wins real cases. Ashby was quiet for a moment. Then he said, "She's right. It was 2 words." He said it while looking at his notes, not the room. But the room heard it. After the students left, Ashby sat in the empty classroom for 7 minutes. Dr. Chen Wei left immediately. Judge Osei Bokie lingered. She packed her materials with the unhurried thoroughness of someone who has no next meeting and is choosing to stay. "You didn't know she had that in her," she said. It was not a question. "No," he said. "How long has she been in your class?" 14 weeks. Judge Osei Bokie nodded slowly. "I had a student like that once. Sat in the back. Never raised her hand. She picked up her briefcase. I almost didn't call on her for the final simulation. My notes on her said passive." She paused. She clerked for the Second Circuit the year after she graduated. She's a federal judge now. She looked at him. "The quiet ones aren't quiet because they have nothing to say, Leonard. They're quiet because they're waiting for the question that's worth answering." She left. The classroom held his reflection in the window glass, the empty rows, the podium, the projector screen, still showing the First Amendment case heading. The back row, 3rd seat from the right. The one closest to the window. Empty. Simone Okafor received the highest moot court simulation score in the class. The numerical gap between her score and the second highest was the largest in the history of the simulation, which Judge Osei Bokie told the administrative assistant when she submitted the scores, and which the administrative assistant mentioned to the dean, and which the dean noted with the specific interest of a woman who had been trying to create more pathways for non-traditional students in the law school for 6 years and was always looking for evidence of what those pathways produced. The dean called Simone to her office. The conversation lasted 90 minutes. At the end of it, Simone had been offered a research fellowship in constitutional law, funded by a grant the dean had been holding for exactly the kind of project that Simone's moot court argument had illuminated. A study of compelled speech doctrine's application to emerging digital platform regulations, which was, as the dean explained, one of the 3 or 4 most consequential unsettled questions in First Amendment law at the moment. Simone accepted it. She went home and told James and called David and texted Kessia and Ruth, and at dinner that night her youngest daughter had asked what compelled speech doctrine was, and Simone had explained it over the pasta in the particular way that her paralegal years and her law school months and her 44 years of paying close attention to the things that required it had produced, clearly, precisely, with all the relevant context and none of the condescension. Ruth had said, "So the court has to decide whose voice it is." "Yes," Simone said. "Exactly, that seems like it should be obvious." "It does," Simone said. And yet. Leonard Ashby sent her an email the following Monday. It was brief. He had written it and revised it several times, which was visible in its brevity, the compression of a man who has more to say than he is willing to say in an email but understands that some things require a start. He said he had reviewed her moot court materials and her research methodology, and that he wanted to know if she would be willing to serve as a research assistant on a project he was developing about compelled speech doctrine's doctrinal coherence. A project that, in the aftermath of the simulation, he had found himself unable to avoid beginning. He said the project had a gap he had not previously identified. He said he thought she might know where to look. She replied within the hour. She said yes. She said, "I found a 1974 administrative law case in the 7th Circuit that I think you'll find relevant. I'll send it Monday." She sent it Monday. He read it Monday evening. He called her Tuesday morning. "Where did you find this?" he said. "It wasn't in the database we use," she said. "I had to search the archive." A pause. How long did that take? She thought about it. 3 evenings. It's not a fast search. Another pause. The kind that contains more than one question but can only ask one. Why didn't you bring it up in class? Simone was quiet for a moment. She thought about 14 weeks, about the back row and the window and the quad below it, and the taxonomy she had understood she'd been placed in from day one. She thought about the star in her notebook next to the doctrinal flaw in week 4. She thought about 11 years of finding the case that nobody looked for. "I was waiting," she said. "For what?" "For the question that needed it," she said. 3 months after the moot court simulation, the Alderton Law Review published a note, a student article, a rare distinction in a journal that received hundreds of submissions annually, co-authored by Simone Okafor and Leonard Ashby. The note was titled, "The Attribution Problem, Compelled Speech Doctrine, and the Emerging Digital Platform Cases." It was 12,000 words. Simone had written the core analysis. Ashby had contributed the doctrinal framing and the section connecting the argument to pending circuit splits. The collaboration had required 6 months and had not always been easy. Ashby was a man who had spent 19 years being the authority in the room and learning to work with a student whose analysis he was not always certain he could improve was a form of professional growth that was uncomfortable and, ultimately, good for him. He said so. Not publicly. In a faculty meeting where the dean mentioned the publication and praised the collaboration, he said, "I learned more from this project than I have from any project in recent memory. Simone Okafor is going to be a formidable attorney." He meant it. By then, he had read enough of her work to know it without any remaining qualification. Simone heard this secondhand, from a friend in the faculty meeting. She was in the library at the time, at a table in the back corner, not because she preferred the back, but because the back corner had the best light and the least traffic, and she had 200 pages of circuit court opinions to read before Thursday. She looked up from the stack of opinions when her friend texted her what Ashby had said. She looked at it for a moment. Then she put her phone face down on the table. She picked up the next opinion in the stack. She began to read. She had work to do. She always had work to do. The back corner was quiet, and the light was good, and the opinions were full of questions that nobody had answered correctly yet. She was going to find the answers. She always did.